watching the award-winning GHS-TV, Germantown Community Television, your hometown news and information station.
Welcome back. I'm Vincent Perryman, and you're watching LegalEase. Joining us on our show is Edgar Davison. We are discussing employment law. Ed, before the break, we sort of talked about what the different flavors, if you will, of wrongful discharge are. If I'm an employee and I feel that I've been wrongly terminated or my rights been violated, what steps do I need to do in order to bring an action?
Okay, the first thing you need to do if you're terminated is to find out all the reasons you have been terminated. Make sure that you create a paper trail. Ask your employer why they did what they did. What's their basis. Make them put that on paper if you can. A lot of times they won't do that, but at least attempt to. And document yourself. Make good notes and good documentation of everything that goes on during the termination process. If there is a grievance procedure you can go through at work, you need to go through that. If there are any steps you can take after the termination or during the termination. Many companies, especially large companies, do have a grievance procedure that you can go through. And of course, if you're with a union, you should use the union to grieve your termination. If it's a harassment issue, you need to make sure that you go through your human resources department and document with them, as well as make documentation yourself, just like you would in a wrongful termination. Use the HR department at your company, because if you don't, the company can later come back and say, well, we had all these procedures and policies in place for you to utilize, and you didn't. And sometimes that can be used as a defense.
So when you say if the reason is harassment, you're talking as if you were harassed in the firing or that you were fired for harassment?
I'm saying that if you were harassed personally, if someone sexually harasses you on the job, you need to make sure you report that to the Human Resources Department. Okay. Or harasses you for any reason, for that matter, not just sexual harassment. If you're terminated, and I didn't say this before, you think it's wrongful or discriminatory, you should also contact an employment lawyer, while you're reporting through HR. Mm-hmm. And they can guide you through that process where you don't mess up. There's also the EEOC. That's the Equal Employment Opportunity Commission. You must file, and this is very important, in Tennessee, if you feel like you've been discriminated against, you must file within 300 days of that last discrimination, that last discriminatory act. So, you would make sure, and a competent employment lawyer would do that for you. Okay. Or be able to help you through that process. And I always recommend people to get an attorney to do that, because there are certain things you need in your EEOC. It's called a charge of discrimination that kind of starts the process. And with Title VII, you're required to go through the EEOC before you file, okay, but not under the Tennessee Human Rights Act.
So as far as, I guess what you're saying is you've got to not only go through all the internal procedures of the company that discharged you, but then also jump through the filing with the state agencies.
Right. The EEOC is a federal agency, okay, but you have to go through them before you are able to file an actual complaint in federal court or state court. That's under Title VII or the Americans with Disabilities Act. It has to sit in the EEOC at least 180 days before you can ask for what's called your right to sue letter. The EEOC will issue that right to sue letter upon your request, or at times they'll dismiss your case and just issue you a right to sue. And you have to attach that right to sue to your lawsuit. and that is a prerequisite to filing a Title VII or ADA complaint.
Okay. Yeah, it's actually one of these things that you don't realize how complicated all of this is, and you definitely need that guidance of an attorney to help you out.
Right, absolutely. If you can get an attorney, absolutely would get an attorney to handle the EEOC process and the state law complaint, because I see so many people, try to do it themselves, and certain things aren't done exactly right, and the courts are very nitpicky about these cases.
Well, and then I guess one of the questions with the going through all of the internal policies, you've been discharged, you've been fired. You still have the rights to go through internal policies, or are we talking about going through an internal policy prior to the discharge?
Well, usually depending on the company, there are grievance procedures that you can go through after your termination many times, especially in large companies. And I always, you need to go through those processes, but at the same time, you probably need an attorney to assist you with that. Mm-hmm. A lot of times your attorney can't be present, but you can always seek advice before going to any kind of post-termination hearing or filing any post-termination documentation.
Okay. Yeah, and I guess on this, are there certain documents that your employer, when they discharge you, are required to give you as they shuffle you out the door?
Under Tennessee, no. They don't have to really give you anything. You generally get a termination notice. And if you file unemployment, which if you can't find a job immediately after termination, you generally would file for unemployment. That's usually fine for you to do. You would get a separation notice from the Department of Labor. On that separation notice, it will give some reason for your termination. It's not always the correct reason, but they will give some kind of reason. And generally, unemployment is employee-friendly. Initially, you may get denied, but if you get to the hearing stage, you'll usually obtain your unemployment. You just have to keep in that appeals process. So I advise people, if you're first denied unemployment, then just appeal it and get your hearing. Because many times the employer won't fight it after that, and the burden is really on the employer to prove any misconduct or anything of that nature, which would keep you from getting unemployment.
Okay. When we return from our break, we'll talk more with Edgar Davison about employment law. Please stay with us.